Hello everyone and welcome to our webinar. My name is Katie Sullivan and I have the honor of introducing the presentation you're about to view. One of the most common concerns that we hear from practitioners is how to navigate the HIPAA compliance maze. The typical small to mid-sized practice has so much on their plate already, and legal requirements to maintain proper HIPAA adherence is something that can oftentimes feel overwhelming, not to mention time-consuming. We want to make it easier for you. So that's why it is our pleasure to have your time and attention, and we hope to shed some light and put your mind at ease when it comes to HIPAA. We will begin by welcoming Rebecca Herold, who has been a HIPAA compliance expert for over 2 decades, recipient of countless industry accolades, and an all-around wealth of information. Her presentation on HIPAA overview for your practice will no doubt feel as informative as it is helpful. Rebecca will then turn over the reins to welcome Dave Greek, our HIPAA Solutions Technology expert, who will then provide information on the valuable resources at your disposal to conquer your own office's HIPAA compliance structure. Now let's begin by welcoming Rebecca Herold. Rebecca, take us away.
Let's start with a quick overview of HIPAA. So what is HIPAA? Well, HIPAA is the acronym for the Health Insurance Portability and Accountability Act that was passed by the U.S. Congress in 1996. Now, HIPAA was established to provide the ability to transfer and continue health insurance coverage for millions of American workers and their families when they change or lose their jobs. Now, when they were thinking about this, they thought, as we're sending this information from one employer to another, we need to make sure that that information is protected. So HIPAA also included some safeguards to help reduce the healthcare fraud and abuse that could occur. It also established mandated industry-wide standards for healthcare information on electronic billing and other processes, and it created some specifically required protection and confidential handling and protected health information requirements that all healthcare providers, insurers, and clearinghouses have to follow. The Office of Civil Rights, which is under the Department of Health and Human Services, enforces HIPAA, privacy rule, security rule, and the breach rule under the HITECH Act. Now, HIPAA consists of multiple rules. The HIPAA privacy rule establishes national standards to protect individuals' medical records and other health information, and it applies to covered entities. Covered entities include health plans, which are your health insurance companies, healthcare clearinghouses, and all types of healthcare providers that conduct certain types of healthcare transactions electronically. And it also applies to the business associates of all the covered entities. And business associates are those entities that healthcare covered entities hire to do work for them that also have access to protected health information, or PHI. The HIPAA security rule establishes national standards to protect individuals' health information that's created, received, used, or maintained by a covered entity. The security rule requires appropriate administrative, physical, and technical safeguards to ensure the confidentiality, integrity, and security of electronic protected health information. And I'll tell you more about this in the upcoming slides. The Transactions and Code Sets rule cover transactions and electronic exchanges involving the transfer of information between two parties for specific purposes. Now, the Transactions and Code Sets rule is outside the scope for today's discussion. There's also the Unique Identifiers rule, the National Provider Identifier, and it's a part of the HIPAA Administrative Simplification Standard, and this is also outside the scope for today. The HITECH Act established additional important privacy and security requirements, and I'll cover those in some upcoming slides. The Omnibus Rule increased the protection and control of protected health information, which I will also reference as PHI for short, so if you hear PHI going forward, that's what I'm talking about. The Omnibus Rule expanded most of the security and privacy requirements to also apply to the business associates, who I will also call as BAs, of the covered entities, which I may call CEs, that receive protected health information, or PHI, such as contractors and subcontractors. And that's an important point. HIPAA also now applies to the subcontracted entities that are used by VAs. There are also a couple of pending rules under HIPAA, and you need to keep in mind that as time goes on, there will occasionally be proposed rules, so you always have to stay aware of that and know when new requirements are enacted. Here's a couple of them. There was a notice of proposed rulemaking, which you'll often hear called an NPRM, that was released on January 7th, 2014, and the purpose of this was to remove unnecessary legal barriers under the HIPAA privacy rule that could prevent states from reporting certain information to the National Instant Criminal Background Check System. There's also another upcoming rulemaking that you may see very soon that will expand an individual's right to receive an accounting of disclosures under the HIPAA privacy rule. And this means you have to keep track of who has accessed PHI, protected health information items, along with the date, the time, and so on, in case the patient's asked to have this information provided to them. And this will be a requirement, expanded requirement, under this proposed rule. So what is PHI? I found over the decades that many covered entities and business associates really aren't clear about what types of items fall under the definition of protected health information, PHI. I found most business associates don't know what PHI is at all, and they have an incorrect understanding, or they don't think they need to know. First of all, let me clarify. Both covered entities and business associates definitely need to know what PHI is. And PHI comes in many forms, and it's not just digital, and that's also another very important thing to understand. PHI can be hard copy information, it can be information you hear, and it can also be information that you see. There are 19 specifically named PHI items, along with a catch-all description of anything that can be linked to an individual. Now, it started out that there were 18 originally, but a couple of years ago, genetic information was added to this list. The key point is that if any of these data items is created or received by a covered entity, which again would be a healthcare provider, a health plan, or a healthcare clearinghouse, then it is considered to be protected health information items. Now, it's important to understand that if these same information items are created and used outside of the healthcare industry, such as in a retail environment or in a classroom setting that's not related to healthcare, then generally these items are not considered to be PHI under HIPAA. HIPAA applies, again, to healthcare providers of all kinds and all sizes, and their business associates, and of course the healthcare insurers and healthcare clearinghouses. Now, each of these items are considered to be PHI items on their own, as well as in combination with other types of PHI items. So a lot of organizations have told me, well, names aren't considered to be PHI, right? Because those names can be found online. Or I've also had covered entities and business associates say, well, if we find this information online, then it's no longer considered to be PHI, right? No, this is wrong. You have to consider the context of PHI. So if you have a name associated with a healthcare provider, you have to protect that name. It doesn't matter if that name could be found elsewhere. It's always going to require protection under HIPAA, regardless of whether or not it may be found elsewhere in a different context. As a result of the omnibus rule, generally all business associates now need privacy policies and procedures that are appropriate to the services and products that they're providing to covered entities. And of course, all covered entities must address all of these topics you see here on the screen. This means that each must be considered and there must be documented policies and procedures that cover each of these topics listed. It does not matter the size of the covered entity or business associate when it comes to HIPAA compliance. The smallest one-person business up to the largest corporation with hundreds of thousands of employees must comply with all of the HIPAA requirements. The HIPAA security rule contains 3 categories of controls, all of which must be addressed by covered entities, business associates, and the subcontractors of business associates. What you see here lists the categories that must be addressed for the administrative safeguards. Basically, those activities that are related to human activities and operational types of issues. Again, this means that each topic you see here must be considered, and there must be documented policies and procedures that cover each of these topics. As previously mentioned, it does not matter the size of the covered entity or business associate when it comes to HIPAA compliance. So, regardless of the size, every covered entity and business associate must comply with all HIPAA requirements. After a breach in response to a complaint or during a scheduled audit, you can bet that the regulators that come in will check for all of these things. The second category is for required physical controls. This slide lists the categories that must be addressed for physical safeguards. Those activities that involve getting physical access to the computing machinery, the storage devices, the hard copies of media containing PHI, and so on. Each topic you see here must be considered, and there must be documented policies and procedures that cover each of these. Now, also, it's important to understand that this includes the work areas that are away from your office, such as when you're working from home and when you're working while traveling. The third security category under the security rule is for the required technical controls. This slide lists the categories that must be addressed for the HIPAA technology safeguards. These activities involve such things as for the systems, applications, networks, and technology devices containing or accessing PHI. So each topic you see here must be considered, and there must be documented policies and procedures that cover each. So high-tech now covers all the topics shown here in addition to what we just previously discussed on the other slides. It's worth noting that any compromise of protected health information is presumed to be a breach unless it is shown after an assessment that there is low probability that the protected health information has been compromised. When you're doing this assessment after a breach, you must consider the technical, administrative, and physical factors that were involved. There are new penalties under the omnibus rule, and they are significant. A maximum penalty amount of $1.5 million annually for each type of violation. So if you violated 5 different standards requirements, which were detailed within those many different topics listed on the previous screens, and it was determined that you did it willfully, meaning you knew that you were not in compliance with HIPAA, but you did it anyway, basically, then the fine could be as much as 5 times $1.5 million, which is $7.5 million. By doing due diligence, which would include such things as providing training, doing risk assessments, and having documentation such as for your policies, your procedures, your activity logs, your access logs, and so on, this will help to put an entity into the lowest penalty category if a breach does occur. The information you see here was taken from the Department of Health and Human Services HIPAA enforcement page. Now, these penalties were applied to some of the smallest clinics and offices up to some of the very large health insurance corporations and hospital systems. In addition to the monetary fines, the Department of Health and Human Services also applies a time period, and it's usually between 10 to 20 years, during which time They will basically continuously monitor your operations and ask you at any point in time to provide to them verifying proof that you're following all the legal requirements from HIPAA and HITECH. So there are a lot of things to address, right? I'm now going to quickly cover the 5 most common HIPAA non-compliance areas that I've seen over the years. No documented policies or procedures. Policies and procedures must exist and they must be documented. And they also must be customized to the organization's business environment and risk, and they need to be kept updated to reflect the changes in the business, as well as changes in applicable laws. The regulatory review reports almost always include the lack of documented policies and procedures as a finding in their audit reports, such as shown here in this excerpt that came from one of the reports from an audit that was done at a covered entity. Here's some more excerpts from some other Department of Health and Human Services regulatory audits that explicitly list the lack of documented policies and procedures. Remember, if you do not document your policies and procedures, then they basically do not exist in the eyes of the regulators. They will also check to ensure you are actually following them. No or old risk assessments. The findings of the Office of Civil Rights 110 HIPAA audits that they performed in 2012 revealed that most organizations had not done a risk assessment. Of those that did, they had not done a risk assessment in over a year, and in some cases it had been 5 to 10 years or more since one was done. So definitely make sure you regularly do a risk assessment. And at this time, just a reminder that not only does the Department of Health and Human Services Office of Civil Rights do these scheduled audits, HIPAA audits, but you can also have an audit or an investigation done following a breach. If someone submits a complaint to the Department of Health and Human Services, you could also be subjected to an audit. And the HITECH Act gave every single state attorney general's office the ability to also go in and enforce HIPAA. So every state attorney general's office can also do audits and investigations. Here's some more excerpts from the reports and audits and investigations that have been done that show the lack of risk assessments as an investigation finding, which was also a basis for increased penalties. Consider this: the Alaska Department of Health and Human Services was given a $1.7 million penalty for HIPAA non-compliance, and a primary issue was that they had not done a risk assessment in many years. There is usually a finding that proper training had not occurred, and usually no awareness reminders had been sent. Providing regular security and privacy training and ongoing awareness reminders and tips is another really important HIPAA requirement. This is an excerpt showing this importance that came from the Office of Civil Rights site. Now, how do you do training? Well, there are many ways in which training can be provided. The SIMBA system that Dave will discuss in a few minutes includes a training option. I've also written a couple of books on how to provide training and awareness communications and events. The cover of one of those books is shown here. When you outsource or contract another business to do work on your behalf, your responsibility for ensuring security and privacy protections for PHI follows to that business associate. You do not outsource your responsibility for ensuring the PHI you've entrusted to a BA remains secured and used appropriately. The omnibus rule made this clear. The more oversight you provide, then the more you can mitigate your associated liability if something bad happens. These show just a few examples from the news of how business associates have gotten the covered entities they were working for into HIPAA compliance trouble, as well as lawsuits because of their lack of security that then led to breaches. The more due diligence you can demonstrate through documentation and logging as well as through contracting, the less liable you will be when others you've entrusted with PHI have a breach involving it. But there will always be a certain level of liability associated. Your goal should be to mitigate it to the lowest level possible. Improper disposal of PHI. Now, this is not only just for paper documents containing PHI, but also on digital storage devices that are thrown away or no longer used or donated to someone else. Not only computers and tablets and smartphones, but also fax machines and copiers and so on. The first HIPAA monetary penalty was for $2.25 million against CVS Caremark pharmacies for throwing away prescription bottles with the patient's information still on the labels into the public dumpsters behind their stores. This relates directly to the physical safeguard requirements, and this penalty was before those penalty amounts were increased that I showed you on the previous screen. Many believe that if this penalty was applied today for the same situation, it would be up to 10 times the amount that they got back originally with this $2.25 million. And here's another example of improper disposal. Improper disposal of PHI on hard copy, in old computers, on storage devices, in copy machines and fax machines, and many other type of situations has been a problem for decades, and it's still a widespread problem. So that's a really quick overview of HIPAA and a really quick discussion of 5 common HIPAA non-compliance issues.
Hi folks, my name is David Greek, CEO of HIPAA Compliance Tools, and I really want to welcome you to this webinar. I hope you enjoyed Rebecca's educational materials. I know those slides were a lot, but basically HIPAA is a lot. It definitely can be confusing. I'm gonna outline a few slides. I only have a few slides. I'm going to take about 10 minutes of your time, and I want to run through a program that we have that I think you'll find very beneficial. Not to mention, we created a special program for H.J. Ross and American Acupuncture clients, and I think you're going to like it. So please stay with me till the end. Bottom line is, as you just saw in Rebecca's slides, HIPAA can be very confusing. There's a lot of information. And as most of you agree, and even I agree, it's a government imposition. It takes a lot of resources away from the business and a lot of time from our day-to-day operations. But you know, guess what? It's the law. It's required, and as business owners, we have a responsibility to keep our patients' information private. So you know, even though it's a government program, it's necessary. So we have to do something about it. There's no question about it. And here's another fact: the OCR, Office of Civil Rights, initially set up to do random audits this year. And they had slated for well over 500. I think it was in the 1,200 range. And they had an issue with their software. So they postponed audits in the beginning of the year. And now they have just basically announced that they're back on the audit trail again. I guess they fixed their software. And they're going out and they are randomly auditing the smallest of business associates all the way to the highest covered entities, hospital organizations, whoever. Nobody's exempt. And as I understand, the fines are severe and can include even a year in prison. So as you saw in Rebecca's slides, the fines are they add on top of each other, and they are payable, due and payable. And talk about business interruption or even business destroy. Some of these fines and penalties are so severe that they would basically take out a business, and no one is exempt from it. So a random audit is not the only way you can get audit. A breach requires an audit, and there's a few other ways you can be audited and suffer those penalties. So you have to be very careful. Bottom line is you need to get compliant. We have a program called SYMBUS. SYMBUS is a program that we basically feel we finally simplified compliance. We cover all 5 areas of compliance to include security and privacy management, risk management, training and awareness, full third-party oversight, and we offer our policies and procedures. Policies and procedures were created by Rebecca, and basically she took her 26 years of privacy and security experience, her 14 books, and put together the most consolidated, easy set of policies and procedures, so manageable. Where most companies' unique selling proposition is who has the most policies and procedures, we actually think the opposite. We've consolidated our policies and procedures, basically HHS.gov's 5,000 pages, into 19 policies, 19 procedures, and 6 tasks. You can't find that anywhere, and it's a very comprehensive program. So real quick, let's take a look at the Symbis dashboard. So now we're inside the software, and as you can see, it's graphically appealing. It's fully mobile responsive. The right-hand sidebar can be minimized, so you have more real estate in which to work. Looks great on tablets and cell phones. And bottom line, this is where you basically manage all 5 areas of compliance. We have quick notes, we have instructions that we continuously push to you, and we have news that we're always updating. Now this is a nice feature. This is basically our graphical analysis of where you're at in compliance at any given time. The left-hand side of this program is our navigation, and this is the compliance side. We start with tasks, we have policies, procedures, forms, evaluations, which includes a HIPAA risk level evaluation, and that gives you an indication. It's 34 questions. It takes about 10 minutes, and it gives you an idea on a high, low, or medium risk level where you're at in compliance. It also gives recommendations, and it gives a description of the question and how you answered it. It's actually very thorough. Here we have attestations. It's full history and log monitoring as you attest to a policy or procedure. It's noted here in a printable report via PDF or Word document, but it also is reflected on your graph. People like to see a visual view of their status. So bottom line is it's a good thing. When you're complete with your program, all graphs read 100%, and if we need to push you or update a new law and push it to the system, or a new form or a new procedure or a new task for that matter, if something happens in the industry that's required, we basically have the ability to push this immediately to you, so you are never out of compliance. Your graph bar adjusts, you're sent a message basically through this message system, and you're notified that there is a task or a project that needs to be done in order to stay 100% compliant. That's why we have a membership. So you're always active in the program, and we're trying to keep this as engaging as possible. Here we have the ability to frame other websites into this program. So like a Office of Civil Rights or a Health and Human Resources site can be framed in here for quick reference. And here's our audit feature. We have full audit management where you can completely add notes, full individual file repository for each audit. You can assign tasks to employees. It basically covers everything. Same with breach. In the event that you have a breach, you need to manage that breach. You talk mitigation dates, the date of the breach, the number involved. You can print notes, add reports, assign tasks to employees, and basically have a desk reference that you can print out with a full report and your findings for future discussion regarding the breach. Here's a new section where we have a full reporting feature that we're adding, and it'll give full graphical reports and analysis. And it's just terrific. Now again, this is the 30,000 foot overview, so I'm not going into individual tabs, but you can get an idea of how powerful this program is. So on the right hand side, this is more of the administrative side, not the compliance side. Here's where you'll add users. You can add employees and set specific training to them, to each employee based on what department they're in. You can review our training programs that we push to the program, and you have the ability to push your own training. You could set the required pass score rate. You can pull videos from YouTube, and you can create a test. The test can be true or false, multiple choice, or basically anything, and it even gives recommendations on the questions. You have the ability. You can also set the pass-fail rate. Some people like 90% pass rate. You can do 95%, or you can even require 100% if you want to. Tracker is our complete separate third-party business associate management system. It's a powerful vendor management system that gives reports. It manages basically the entire relationship between you as the administrator or the covered entity and the business associates that you deal with. Each business associate gets its own private dashboard where you can manage the relationship. There's an upload feature and it's very, very efficient as far as pushing certain information or requirements, including a business associate agreement. And the business associate agreement can simply be signed and re-uploaded into a file repository that is assigned to that individual tracking company. So it's very efficient. There's a full file repository within the program, and then we offer full support. Support can be a number of things. If you have a feature request, because again, this program is a little less than a year old, and we're getting some phenomenal feedback from our new clients, and we have the ability to add features very quick. We're not like a regular software company where we put it on a list and it takes us 2 months to get to it. If it's a feature request that we think everybody's going to like, it's a matter of hours, not days. So we're very glad you're looking at the software, and we're hoping that you give it a try. So let's jump back to the platform real quick. So again, we have compliance simplified. There's no question about it. You saw it. And what's even better is, as I said before, we got a special program for H.J. Ross and American Acupuncture Council. So I have a good relationship with them. I've known them for 4 years. In fact, basically that's how I'm involved in HIPAA compliance. Rebecca and I created the program, and once I was finished with it and once I thought it was good enough, I circled back and I made this offer for a limited time to get everybody compliant within H.J. Ross and American Acupuncture Council for $6.99 a month. That's the membership fee. It's a limited time, and basically we're charging, I think, what is that, $84 a year? So you pay $84 a year for every aspect of compliance. It's unheard of. It doesn't exist, and it's going to be taken off probably within the next 2 weeks after this webinar, and I'm just hoping that you jump in, you take a look at it, you start your project, and once you're in there, I know you'll love it, and it's very important to get compliant. And again, there's absolutely no long-term contract, and there's no hidden fees. If you pay the $6.99 per month on our site, HIPAAcompliance.org website, we're offering this program for $19 a month, so that's 66% discount. Now, additional features, and I know we've already looked at the platform, but we have a private custom dashboard. We have customizable policies and procedures with a full edit feature. You create the policies and procedures, you edit them, and then you print out your basically manual. That's your desk reference, but you always have the ability to go back and review the original. We have full HIPAA training and awareness, audit and breach management. We have our vendor third-party Symbis tracking software, a full file repository, and much, much more. The beauty of it all is jump into the program, drop $6.99. You got a full 30-day money-back guarantee to take a look at it. You can contact us for support. We'll answer the questions as soon as we can get to them. We're expecting a fair amount of new clients with this slide at this price. So with this software at this price, so we're excited to get to it and answer your questions. And here's how you order. It's a special order form. It's branded to American Acupuncture Council, and H.J. Ross Company. And here's the domain. Acupuncturists go to aacinfonetwork.com/HIPAA. Chiropractors can go here, hjrosscompany.com/HIPAA. And if you have any questions, simply call 800-562-3335, and they'll answer your questions. And if you have questions for me, or if you need a private demo, or if you're interested in licensing, ask the people over there at American Acupuncture H.J. Ross to get a hold of Dave Greek, and I'll help you out in any way I can. And remember, there's a full 30-day money-back guarantee, so we're hoping to see you inside. Thank you so much.